Good. Well, welcome everybody to the European Law Institute's webinar on product liability and digital harms. I'm the first vice president of ELI and I'm chairing the session today. We've got, I think, some very distinguished speakers, and we'll be discussing ELI's first supplement to the ELI draft of a revised product liability directive. And it's obviously a very high profile and interesting subject and deals with really whether providers of social media platforms, AI chatbots, and comparable digital consumer offerings are going to be exposed to liability under the EU's new Product Liability Directive of 2024. And the speakers we've got to discuss this question and to discuss ELI's recent document, are Christiane Wenderhorst, who is ELI's scientific director, formerly president of ELI, professor at the University of Vienna, who was very much involved in the preparation of the ELI's document. We have another past president of ELI, Pascal Pichonaz, Professor Pascal Pichonaz, at the university, professor at the University of Fribourg, professor of Roman law, but he knows so much more than that, so hopefully it won't all be in Latin, Pascal. And then we have Christian Twigg-Fleschner, a professor at Warwick University, also involved in the preparation of ELI's work in this area. So I don't want to take time in making introductions, and so what I suggest is that we proceed as quickly as possible. There will be three presentations. First from Christiane, setting the scene and giving an overview of ELI's historical work in the field. Then a substantive presentation from Christiane concerning the ELI supplement and the liability for defective software under the new Product Liability Directive. And then we finish off with the third presentation from Professor Pichonaz, entitled Striking the Right Balance, Consumer Protection, Innovation and Legal Certainty. Is the new liability regime proportionate? He's going to talk about burden of proof and disclosure of evidence. This is obviously a fascinating subject because of the interface between private law, between EU law, and also, as mentioned in the document quite extensively, the position in US law. And just before we start, I'll declare my interest because I'm chairman of something called the UK Jurisdiction Task Force, and we have just published our legal statement on harms caused by AI, liability for harms caused by AI, which sort of sits in the middle or on the fringes of all this. So without further introduction, can I hand over to Christiane for a scene-setting exercise? Over to you.
Thank you very much, Sir Geoffrey, for your kind introduction. My task in this session is to do exactly that, to set the scene and give a bit of a historical account almost of the work undertaken by ELI in the field of product liability, and in particular, the reform of product liability laws to align the law with this important development that we've seen in recent years, the rapid digitalization, the arrival of complex digital products and digital services. So what I will do is I will give a quick overview of the different projects, reports, outputs ELI has prepared in recent years. I will just dive into one or two of those to highlight what we've already said in ELI's work about the importance of extending the reach of the product liability regime to the digital field. And I will then set up Christiane for her presentation about our most recent work on well, I won't say anything yet. I won't give it away because this is all for Christiana to reveal in due course. But if we think about how it all started back in 2021, or indeed in 2020, I was asked by the ELI Council to prepare an innovation paper, which is a particular type of paper ELI produces, where we try and not give concrete final answers to complex questions, but to start a debate. It's very much designed to launch a debate, and that's precisely what we did in 2021 when we published the guiding principles for updating the Product Liability Directive for the digital age. I will say a few more words about this in a short while. Following that innovation paper, there was some movement at the European level. The European Commission picked up the idea of pursuing reforms of the Product Liability Directive. And there were a number of consultations. First, the European Commission's public consultation on civil liability, adapting liability rules to the digital age and artificial intelligence, for which we prepared a response and created a sort of quite a large working group. Pascal and Christiana were both heavily involved in that, alongside several other colleagues such as Bernhard Koch, Jean-Sebastian Borghetti, and others. And apologies for not mentioning everybody. We then went one step further, and this is based on work that Christiana had already been involved in, which is to create a draft of a revised Product Liability Directive. Now, we spent some time within this working group to put together this draft, and when the European Commission started to prepare its own draft directive, the ELI draft was quite influential on what was put forward, although not entirely followed. And I will say something about the main differences towards the end of my presentation. And then, of course, the European Commission published its own consultation on. Sorry, something's happened here on my screen. Have you lost? Can you still see my slide? I've lost things now.
Yes, we can still see your slide.
Thank you. Something weird happened on my screen. So let me come and talk about the ELI innovation paper, which of course started in 2020 when there was actually nothing much happening with regards to product liability at the European level. By the time we started work on the innovation paper, the PLD was already more than 35 years old. It had been around for a long time and had never really been updated much. There had been an amendment towards the end of the previous century when primary agricultural produce was made a key element of what's within the scope of the notion of a product, in light of the BSE crisis that was particularly prevalent, of course, in the United Kingdom at the time. But no other changes were made to the directive either before or after the 1998 amendments. The PLD is very much a product of its time, or was a product of its time, I should say, because it is no longer in force. It is based on very much the traditional patterns of linear manufacturing and supply of physical goods. And because of its age and because of the quite basic state of digital technology in the 1980s, there was no real account taken of the significance of digital technology, digital products at the time the first directive was drafted. Now, that might have been understandable back in the 1980s, but it makes no sense anymore well into the 21st century. In particular, as many delegates will be familiar with, the main developments that have raised questions is the extent to which the integration of software into physical goods to provide the functionalities of those goods is something that the existing directive covered, or to what extent there was a gap already. There might have been little confusion around preloaded or static software, preloaded to control some functionalities. I think in many countries that would have been accepted as being part of the notion of a product. But things got a little bit more difficult and certainly more uncertain when it comes to products which have the capability of connecting to a network, the internet, where software can be remotely updated, and therefore where the software preloaded on physical goods takes on a dynamic form. The functionalities can be controlled remotely, can be added to, but also removed. A big concern now with so many digital products. In addition, the growth of software, the complexity of software, apps on smartphones and so on, all of these were matters that weren't taken into account back in 1985. And of course, most recently, the big challenge is how we deal with artificial intelligence and the liability question this prompts. And this, of course, is something that Christiana will cover in much more detail in a moment. The other thing the original directive did not take into account are the typical business models that have evolved in the digital economy, in particular the platform economy, but also the much more recent practice in light of sustainability concerns to refurbish, to recondition products and offer them again to customers on the market. So at the time we prepared this innovation paper, the Commission had published several reports reviewing the operation of the directive and had concluded at regular intervals that there wasn't really much need to do anything yet, or indeed at all. We felt in ELI at the time that there was indeed now something that needed to be done, that we couldn't wait any longer, and therefore we started to put together this innovation paper where we ultimately set out 10 guiding principles which we felt were important in starting a conversation about reforming the PLD. Now, I won't go through all 10 of those in my talk because, of course, we've moved on a long time, but I wanted to flag up some of those principles. And the first principle was to remind everyone that the key factor of the PLD, and this is indeed what the PLD already tried to do back in 1985, is to ensure that there would be a simple mechanism to allow an injured party, a party who has suffered harm as a result of using a defective product, that this party can seek compensation in a straightforward manner. Wouldn't be too tied down by complex processes, identifying correct defendants, and so on. And of course, the PLD, the original PLD, had already done this by having an extended reach of parties that could be held liable. Secondly, and this is where things become particularly relevant to today's session, we very firmly argued that the notion of product should be updated to include both goods with digital elements, in other words, physical products that rely on digital elements for functionality and so on, and digital content and digital services supplied as separate digital products. And we used the phrasing deliberately, and we argued for aligning the terminology of the PLD on these points at least with the existing legislation, particularly the 2019 twin directives on consumer sales and digital content and services. This would have provided both clarification and an extension of the reach of the PLD, because that would have meant that purely digital products, whether that's smartphone apps, software, or indeed AI algorithms, would also be covered by the directive. Similarly, the notion of defect required review to allow for the particular features of digital products to be taken into account, and also to move away from the old PLD's regime of one-time supply. Because as I said earlier, many of these products are regularly updated remotely via the internet, and therefore the idea of a single point of supply seemed to make very little sense for all of these products. Similarly, we argued back in 2021 that the notion of damage was very much in need of review. In particular, it should be extended to include damage to digital elements and data, and not just to physical property. And it should also be extended to potential loss of data, or at least leakage of data. And of course, another question that happened in the background, although we didn't address this specifically in the innovation paper, but it's relevant for today, is the possible extension or clarification that the directive includes psychological harm. We then prepared a draft directive, and in the draft directive, you can see I've just put some extracts on the slide here, highlighting provisions to show how ELI suggested a way forward. For a start, there should be a clear alignment between this directive, or a new PLD, and the existing rules, in this case, Directive 2019/770, the Digital Content and Digital Services Directive, by adapting this terminology. In 1985, there was no other legislation with which the PLD could have been aligned. In 2021, we have, or 2022, we did have a lot of legislation, and it made sense to us to ensure terminological consistency. We also added other suggestions around, for example, professional refurbishment. And indeed, we also recognized that the fact that updates are provided should not by itself mean that liability can't arise at an earlier point. In Article 6, we extended the notion of relevant harm or damage, if you want to use the original PLD's terminology, to include damage to files as a very broad notion, and the leakage of personal or other data. So again, reflecting the particular features of the digital economy. And in the notion of effectiveness itself, we highlighted several elements that again reflect features of the digital economy, whether that's interconnecting multiple products, security features to protect a product against external influences, cybersecurity, in other words, or indeed the evolving learning and predictive functionalities of a product. So we made a very strong argument for a number of important reforms. The European Union then moved very, very quickly to adopt its new PLD. It was adopted in November 2024. And indeed, the directive takes up many of the suggestions ELI made in its various reports. But it does not follow one of our key suggestions, a recommendation that goes back to the 2021 innovation paper, that the PLD should be aligned with the terminology used elsewhere. Instead, the PLD only refers to software. And recital 13 explains what is included in the notion of software. And you can see there from the slide, it includes operating systems, firmware, computer programs, applications, or indeed AI system, whether standard placed on the market as a standalone product or provided through the cloud, through a communications network, or as a software as a service model. But of course, crucially, information is not covered by the directive, something that was already the case under the original directive. Now, this is the position that we got to after a number of our reports and the EU's own legislative process. But the problem is the notion of software, because it doesn't neatly cover digital content and digital services in the way that we proposed, this inclusion of software leaves open a number of important questions. And it is those very questions which have now arisen and are dealt with in the supplement, which I will hand over to Christiane to say more about.
Thank you very much, Christian. I should have probably mentioned at the beginning that if you have any questions arising from any of the presentations, we're going to be discussing them at the end, and you need to put your questions in the Q&A at the bottom so that we can read them out and get the panel to answer them. So without further ado, I hand over to you, Christiane.
Well, thank you so much for inviting me to present this new supplement. And in fact, Christian has already explained why there is now a problem. The problem stems from the fact that the new product liability directive has not followed ELI's advice to use the terms digital content and digital services, but uses the term software instead. And so the question arises, what is covered by the term software that was not included in ELI's previous work? And the reason why this is an extremely timely and pertinent question is that we are seeing mass litigation elsewhere, mainly in the United States, that deals with the question of whether the providers of social media, of chatbots, of similar consumer offerings could be held liable for harms caused, such as addiction, depression, or even suicide. These are harms that are clearly covered by the new Product Liability Directive, which explicitly now includes even psychological harm, something that was arguably the case already under the old directive, but has now been clarified. So the harm would not be an issue, but the problem now is whether the providers of such consumer offerings are producers, whether the consumer offerings I just mentioned, such as social media or chatbots, can be qualified as products under the new Product Liability Directive. Now, this is something which the courts in Europe will have to decide, definitely. We know of several big litigation cases that are already being prepared, and it is for the courts to do that, and ultimately for the Court of Justice to say whether software could be read as including social media, chatbots, and similar offerings. Now, that puts the European Law Institute in a somewhat new and difficult position. Why? As you have seen from the presentation of Christian, ELI so far has mainly engaged in making proposals of how the law should be in the future. The ELI normally doesn't give guiding interpretations of the law as it stands, for several reasons. One of them being that the Court of Justice of the European Union is one of ELI's institutional members. So we do normally not get into the territory of the Court of Justice and try to give kind of authoritative interpretations of the law, because the ELI has no authority to do so. So this is why in the first supplement, where we try to answer the question whether social media, chatbots, and similar offerings could come under the scope of the PLD, we don't say what the right interpretation is. Rather, we outline 3 different routes by which liability could be construed under the new PLD, subject to the court's eventual position, needless to say. So, coming back to what the PLD actually says, as Christian has already explained, the PLD is very brief in this regard. It simply says product means all movables, and so on and so forth. We know that already from the other directive. And now including electricity, that was already under the old directive, but now the new items mentioned here are in particular digital manufacturing files and software. And now the question is, as social media are probably not a digital manufacturing file, the question arises, is it software? Is social media software? Well, at first sight, you might say, well, social media is not software, right? However, when you read recital 13, recital 13 clearly says that software is a product, irrespective of whether the software is stored on a device or accessed through a communication network or cloud technologies, or whether it is supplied through a software as a service model. So that means also software as a service is software, and social media or chatbots could be much closer to software as a service. So here we have a question whether that can be subsumed under software as a service. However, recital 13 also goes on to clarify that information as such is not to be considered as a service, including the mere source code of software is not a product. So, something else that is interesting in the current context is that the definitions define manufacturer as a natural or legal person who develops, manufactures or produces a product, or has it designed or manufactured, or, and that is important, that develops, manufactures or produces a product for their own use. So this is important because evidently the providers of social media or similar offerings, they have software produced for their own use. And another important definition is that of component, which means an item, including an intangible item or even a related service that is interconnected with a product. So these are the definitions and the recitals that are relevant for the analysis. And now comes the analysis provided by the ELI. So the ELI, as I already mentioned, identifies 3 different routes to liability. And the first route evidently being that we have a provider that places software on the market, and that software is then used by end users that suffer the harm. So this would be the most straightforward analysis. So the most straightforward analysis that would mean liability for social media chatbots and similar offerings would be to qualify those social media or chatbots themselves as software placed on the market. Now, there are several hurdles to overcome on that route. The first one is the delineation between software or these offerings and mere information. So that line needs to be drawn, and arguably the line should be drawn asking the question whether the information is content displayed by a system or whether it is information generated in the course of the system's functionalities. So arguably the latter could be included under the scope of the PLD, whereas the former, the content as information displayed, such as advice given by an ebook, for example, or by a website, would not be included. And that would kind of be the issue that causes so much unrest in the United States, where we hold all these debates about First Amendment and so on. But for Europe, arguably, a line can be drawn that way. Is it content displayed, or is it something generated in the course of the system's functionalities? Because then we would look at the generation mechanism. It would be the generation mechanism and not the content displayed at the end of the day. But what is maybe more difficult is the question, what is the delineation between software and a service and a genuine service? Because by using the term software, the legislator could have also expressed that it doesn't want to cover all digital services. And so for that delineation, the ELI tentatively proposes a list of criteria. And the criteria are the following. The first criterion being who decides to use exactly the software at hand for a given purpose instead of alternative means. Then who determines the exact timing, frequency, and other circumstances of activating the software? Who feeds prompts, commands, or other input data into the software? Who primarily exercises human oversight, if any? And who is the first to assess the software's output? Now, if you apply those 4 criteria to a companion chatbot, for example, I believe you will clearly come to the conclusion that the companion chatbot is used by the user. So it is something not provided as a service, but it is something provided to the user as a product to be used by the consumer, for example. Why? Well, it is the consumer that decides to ask something to the companion chatbot instead of browsing in the internet or asking a friend. It's the consumer who decides when exactly and how often to consult the companion chatbot for what purposes. It's the consumer that feeds prompts into the companion chatbot. And it is the consumer who primarily decides whether what the chatbot produces as output makes sense, whether it's useful, whether it's maybe dangerous. So the companion chatbot would clearly qualify as a product under those criteria. But take, for example, a content moderation algorithm, probably the analysis is somewhat different. So that would more likely be used by the provider of the social media. So this is why the ELI also identifies two other routes to liability. And the second route to liability would be the one that builds on that notion of the manufacturer producing software for its own use. So the idea would be we have a social media provider that is not just a provider of social media, but that is also the producer of software such as a content moderation algorithm for its own use. And so the social media provider as a producer puts that software into service and then provides a service to the consumer. Now, is that something captured by the PLD? Well, if we look at the existing case law of the Court of Justice, it could well be. Because we have a ruling by the Court of Justice under the old directive in the Wedfeld case, where the court said precisely that. The only question is whether we can use the doctrine developed in Wedfeld in a situation where the software is closely interwoven with a genuine service. So that will be for the Court of Justice naturally to say. But just to give you the relevant parts of the Wedfeld case and why we believe if the Wedfeld doctrine is applied here, it could be a route to liability. In the Wedfeld case, we had a kidney transplantation, or rather a kidney transplantation that failed. Why did it fail? Well, it failed because the kidney had to be prepared through flushing with a fluid that was produced by the same or by a hospital owned by the same municipality as the hospital delivering the ultimate transplantation service to the victim. So we had a situation where the producer of a fluid that was used in the course of providing a medical service was the same person as the provider of the medical service. And the Court of Justice clearly said, yes, we have liability in that case. Yes, the PLD covers that case. And if we use that doctrine and apply it to the social media situation, then it would become clear that the social media provider might become liable according to that line of argument. And there is still a third route of liability, and that is based on the notion of related service and a component. So definitely, when somebody uses social media, they usually have some kind of obvious software on their devices, right? They have something on their mobiles, which is an app and which is clearly software. What else could it be? So there would be a possibility to qualify the social media service as a related service, a service related to that app. Of course, the open question is whether that is a little bit far-fetched and artificial. So it is not something ELI has mentioned in the very first place, but the ELI mentioned that this would be a third way of arguing why there should be liability in this case. So this is more or less what the ELI in this statement does. Remember, because of its institutional constraints, ELI would not say what the right interpretation is. ELI would not solve the cases. So we would not also say whether and under what conditions there is liability. This would have required a much broader analysis. There are other things to consider, such as the nature of the harm, defectiveness, legal causation. We also didn't address the temporal scope, like for what offerings the new PLD is applicable, whether same results could also have been derived under the old product liability directive. And finally, ELI only analyzed the PLD. There are other bases for liability, including negligence liability under national and EU law. And when it comes to EU law, I would just like to mention Article 55 of the Digital Services Act, where a provider can become liable for failing to take adequate measures to protect minors or other users, minors in particular being addressed by Article 28 of the DSA. So this is something the ELI did not touch upon. But what the ELI tried to do in its first supplement is highlight for the EU situation how the providers of social media, of chatbots and similar offerings might become liable under the new PLD, subject to the views of the Court of Justice. And with that, I would like to thank.
Thank you very much, Christiana, for that very clear exposition of the supplement. And now we're going to go on to Pascal, who's going to look at the balance between consumer protection, innovation, and legal certainty. And the latter is obviously very important, since we would all like to know what this PLD really means. So Pascal, you help us with that. But before you do, I just want to remind people to put questions in the Q&A at the bottom of the screen, which we will start immediately after Pascal finishes his presentation. Thank you.
Thank you very much, Sir Geoffrey. Thank you also for inviting me for this webinar this afternoon. I hope you can see my presentation. Yes, okay, wonderful. So indeed, tort liability is always the result of a balance between conflicting interests, and product liability is not an exception, of course, to this balancing issue. As we know from the legislative history of the PLD, it has been at the core of the creation, the approval of the PLD, the initial one, to find the right balances between different interests. On the one hand, between consumer protection, because it was aimed at consumer protection, but also not capping innovation, ensuring that innovation in Europe can continue, and also, of course, protecting more specifically vulnerable consumers, just to mention a couple of the right balancing issues that came into play, not only in the initial PLD, but also in 2024 version of the reformed product liability directive. Now, between these interests, of course, you have to find the right balance. It depends a lot of different factors. We've just heard Christiane Venteros mentioning the various requirements for liability. I will not tackle all these, of course, but the choice of identifying exactly the proper interpretation of any of these requirements participate, of course, to the right balancing. Then we have also this interplay between EU law and EU law concepts and member state tort law, because the original member state tort law might still play a role in some instances, as we will see in a moment. And finally, of course, and that will be the core aspect of my presentation, the issue about evidence and burden of proof, because you may have a very nice structure. If it's impossible to prove anything, then the decision where the burden of proof lies will be central. Now, addressing the issue of liability for social media, bots, and similar devices does not only raise issues about its scope, about what is a software, what is a software as a service, but and not even issues about services and ancillary products. It does not only raise issues about the compatibility of the new LPD regime and the limits of the so-called maire conduit immunity regime for platforms, because most of the time these social media and other bots are on platforms. And as we know, Article 6 of the DSA has revised these platform liability in line with the L'Oréal approach of 2011 and with the Peterson case above all in 2018, where the Court of Justice of the EU said that in most instances where the information is handled by the AI algorithm and it involves a degree of active editorial control, then one would not be totally immune. That will be considered as an active host, to take the proper terminology. Now, all this is nice, but you have to come up with some proof and take into account the burden of proof. So let's go back to these provisions of the new 2024 PLD and Article 10, which states, of course, the general principle that claimant has to prove effectiveness, damage, and causal link. That's not new, of course. That's just to mention it. It goes back to Roman law already, as Sir Geoffrey mentioned. We are based on this approach. But of course, at the same time, of course, one needs to be able to bring element of proof of evidence, and that's not easy when the platform, the social media, the bot is in the hand of the provider, and that the users has just an access but has nothing else than its access. That's why the new PLD provided for a duty to disclose, provided for in Article 9. And this duty of to disclose, I would say it's a kind of mild or balanced duty to disclose. Why? Because first of all, it's bilateral. So the defendant, the provider, is required to disclose relevant evidence that is at disposal. So of course, the question would be, what is relevant? Who decides what is relevant? Probably the one who discloses has to, in the first step, determine what is relevant, and then the other party may ask the judge to ask for more disclosure, but that might not always be easy. At the same time, the claimant, the user, the one who claims damages, will be required to disclose relevant evidence at disposal to help the other party to counter the evidence. What this might be, it might be, for instance, cumulative causation, other aspects that could or should be taken into account in order to consider liability. So that's not very clear to me. In terms of certainty, it's far from certain what this would mean. Third aspect, it needs to be considered only if it's necessary and proportionate. taking into account legitimate interests, including trade secrets, of course, as well. But this idea of necessity and proportionality is, of course, central to limit. So you have to imagine it needs to be relevant evidence only if it's necessary and proportionate, and trade secrets, among other aspects, are excluded. So at the end of the day, we don't know exactly what it will be. At least it's certainly not far-reaching, or not as far-reaching as the common law aspect of right to disclose or duty to disclose anything one has in the field of the claim. And finally, and that's the interesting point, I think, it shall be made easily accessible and easily understandable. So, of course, it means that the judge and the parties need to be able to understand that quite easily. We will see how this will be implemented. Now, next to that, of course, you have a further exemption, further aspect, which is the fact that it is often difficult, given the context and the different interoperability, to determine exactly where the problem lies, where the defect lies, what is the causal link aspect. That is why the PLD has provided for a series of presumption. So defectiveness is presumed if there's, first of all, an adverse inference that can be made. That's in a way the consequence of the failure to disclose according to Article 9 that I just mentioned. If the claimant or the defendant do not disclose, then one may be able to take an adverse inference and therefore presume defectiveness when the claimant did not disclose. Secondly, and that's also a tricky point, the non-compliance with mandatory product safety requirements. So for chatbots, for instance, one might ask oneself what that exactly means. Are there product safety requirements for the type of prompting you're inserting and getting out by the chatbot, and so on and so forth? In some areas, of course, it will depend of medical devices, of other aspects linked with AI and bots. You may indeed, and the ELI document gives a number of proposals. And finally, third aspect, about obvious malfunction of the product in case of reasonably forcible use. Now, we were mentioning initially the cases in the US or in Canada regarding the addictiveness of some bots and the also psychological harm that were caused, or sometimes death that were caused through the use of these bots. The question is, of course, whether this is an obvious malfunction of the product or not, whether that would suffice to get to the level of getting a presumption of defectiveness. It's certainly far from sure. That's why I put a number of questions here that I already mentioned. One is, what are the mandatory safety requirements for chatbots, social medias? If one thinks, for instance, of the addictiveness addiction triggered by such bots, is there a minimal age? We are now getting to that in several countries in Europe, like in France recently. Is there a mandatory product safety to protect against mental integrity? Not sure, and further aspects. The same is, of course, true with what I've said about obvious malfunction. Now, a further aspect is a presumption when, despite disclosure, it is excessively difficult to come with a proof, element of proof, as it says here, in particular due to technical or scientific complexity in proving the defectiveness of the product or the causal link between its defectiveness and the damage, or both, of course. And the same when the claimant demonstrates that it is likely that the product is defective, or that there is a causal link between the defectiveness or the product. So you disclose something and there's a likelihood, so the standard of proof has been lowered to likelihood and not to certainty. That's the first aspect. And the second, even if you cannot prove it, because there's a kind of a lack of evidence, then you may have a presumption of defectiveness or causal link. That leads me to the next point, which is the issue of causal link, which is also very difficult in the aspect of chatbots, social media, adaptiveness, and other aspects. Of course, here again, one has to prove the causal link. Now, the causal link issue, here. The causal link issue is, of course, is tricky in itself because member states' law sets up different requirements to the causal link. You have the so-called material causal link or natural causal link, the but-for exercise in a way, but then you have a legal causal link that has to be taken into account, which is sometimes adequate causal link or negligence or remoteness or a number of factors that diverge from one member state to the other. And this is member state law, so that the harmonization and also foreseeability of the outcome might diverge from one system to the other. Now, here again, we have some presumptions provided for by Article 10, subparagraph 3. First of all, the causal link is presumed, and I suppose that's the factual causation that is presumed, where the product is defective and the damage is of a kind typically consistent with the defect in question, obvious malfunction of the product in case of reasonably foreseeable use. Now, when you read that, you see that the questions I've asked already before become even more difficult to answer here, because you need to have an obvious malfunction of the product, which might be very difficult in terms of social media, addictiveness, addiction, and so on. And that is typically consistent with the defect. I'm not saying it's impossible. I'm just saying it's difficult to get the presumption. If you don't get the presumption, you have the full burden of proof. That's, of course, very difficult. And when, despite the disclosure, you are still in difficulties, same here for the causal link, you may be favored with some further presumptions, as I mentioned before. Now, I thought, okay, that's at least one step. And maybe here we can see that a foreseeability of the outcome is not very easy to set. But at the same time, I just want to mention a last, and that will be my final point, a last point, which is the issue of alternate or cumulative causal issue or causal link. Because typically, in terms, if you think of addictiveness of a social media, you may, and that's what is at stake in these American or Canadian cases above all, you may think that maybe that will trigger a suicidal behavior and maybe also a psychological harm, a mental disease, why not? So you may get to the point that you may say there's at least a material causal link and potentially then some legal causal link. But what about additional, cumulative, or alternate causation that may arrive, linked to family issues, to bullying, to pre-existing mental status, and to what extent the mix between these different causes will be considered by courts? All this will, of course, depend from the member states' court, because these issues of alternate or cumulative causal link are matters, concepts of member state courts and not of EU law as such. So one can see that maybe the balance, or let's say the scope was extended, the type of damages were expanded to some extent at least, and the issue of defectiveness and the concept was also made clearer. So you could imagine there's a higher level of certainty, but at the end of the day, one has to realize that despite some level of presumption, it will be quite difficult, it seems to me, to foresee the result of similar cases that we know in the US or in Canada, in the EU, based on what we know right now, and that the Court of Justice of the European Union will need to be, well, creative, or at least be able to find the right balance through the case law, because of course the difficulty of having EU law, member states law, and having different type of evidences makes the whole very difficult. Well, maybe you were not expecting that I would come with more open questions than answers, but at least that's a first aspect which hopefully will trigger some questions for the debates. Thank you very much. So Geoffrey, you're muted.
Sorry, thank you to all the speakers, and thank you to Pascal for finishing off. We're now getting some questions in the question and answer chat, which I'll come to in just a second. But before I do that, I wanted to ask the speakers this question. Plainly, the concept is to extend the concept of products to software, to social media presentations, and to apps, which everybody uses all day long, to create some liability for obvious harms. A different approach would have been to say product liability is one thing and software liability is another thing. AI liability is another thing. It's a completely modern, there could be, or might be, a completely modern approach which didn't spring off physical products and the liability we've developed for physical products, but actually said when one wanted to make software companies, AI companies liable for harms they cause. Because to me, listening to all this, it appears very contrived. We're using something that was developed for physical products, for cars, for fridges and cookers and microwaves, and we're then trying to adapt it to the modern problems of our society. And I just wondered whether the panel had any thoughts on whether that's the good way of doing it, because it seems to give rise to a certain amount of uncertainty from what you've all been telling us. Should I start with Christian?
Yes, thank you. I will just pick up on one or two key factors that shaped our position in ELI, and which obviously also influenced what has now happened in the new EU PLD. One of the big problems is that finding a clear dividing line between something that's purely digital and therefore could be a software liability regime and something that's purely physical has been quite significantly blurred by the emergence of all these products which rely on software, dynamic software, that for their functionalities, which are controlled remotely through apps and through other devices. And therefore, it's very difficult now to say there is a clear line and one bit of problem falls into one category and another bit of problem falls into another category. Ultimately, what we probably would have ended up doing is to replicate a liability system that's very similar, because the key thing that the PLD back in 1985 achieved was to introduce a form of strict liability that reduced an important obligation to prove fault, which was, I think, a major obstacle for so many of these instances. And what we therefore decided when we put the first innovation paper out is to say that, A, we can't really draw a dividing line between the two, or not a neat dividing line. We would have to have a whole bunch of criteria to work out when something is in one or in the other. And because there is a lot of parallelity between what we would do for products and for digital content. Christiana, Pascal, please supplement.
Christiana.
Yes, thank you very much for that excellent question. I largely agree with what Christian has said, and maybe would like to add that since the 1990s, the three principles of technological neutrality, functional equivalence, and non-discrimination have been a cornerstone of lawmaking in the area formulated by UNCITRAL and other important actors in the field. And I personally believe that given the functional equivalence between hardware and software, we are witnessing that most, if not all, functionalities that used to be provided by very traditional hardware are now provided by software. Given that functional equivalence, it would really be very difficult to deny the victim a regime of liability that has proved to be immensely important for victims of harm. So having said that, it is of course not denying the difficulties that come with such a decision. And I think two of the difficulties I've tried to cover in my short presentation. One is drawing a line between, digital something like content services or software, depending on the approach you take, and mere information. So that is certainly a difficult line which you have to draw, assuming you don't want product liability for mere information. And the other is there still that dividing line which we used to draw in the pre-digital era between product and service? Because as Christian has explained, in the digital realm, product and service are not so clearly to be delineated. So these are challenges to be overcome, but by and large, I personally believe it's a right decision given the functional equivalence and the other principles I just mentioned. Thank you so much.
You're muted.
Sorry, Pascal. The question to propose that whether when somebody uses software to deliver a service, there's not going to be the same kind of liability as when you are using products could be regarded as happenstance or not necessarily entirely principled. Pascal.
Yes, first of all, I can, of course, concur with what was said, but indeed, one aspect, even in the examples we took, one aspect is the relationship between tort liability and contract liability. Because, of course, in many of the examples we've taken, we have probably a contract or contractual basis for liability. And indeed, if you have the son of the or the child of the contractual partner that uses the bot or the platform, then it might be a third-party bystander, and then you have different issues about whether the contract is covering that person or not, depending of member state law. But product liability as such, whether it triggers damages on third parties is a first issue. And the second, of course, is do we want to circumvene the contractual liability that has been put in place through the DSA, through member state law, and through the various directives for digital products, digital goods, and so on. That's also one tension which I see, and therefore I think it does, at the end of the day, I'm not sure it will matter so much about whether or not softwares are placed in the scope of the directive of the PLD, because potentially a lot of things will go through contractual liability rather than tort liability.
Yes, well, thank you. Now, the first of our questions from Arishan Said Magambet is about cyber fraud, or about where AI is used to commit fraud. And he asks whether the PLD could also become relevant where an AI system is used by a third party to commit fraud and causes financial harm. and asks where you would draw the line between the responsibility of the fraudster and the responsibility of the AI provider. Any ideas on that? Christiana, you look as if you got the immediate answer.
Well, I don't know whether I have the immediate answer. I mean, when we're talking about fraud, usually the harm caused is pure economic loss. And we should say that, or stress, emphasize that the PLD still does not cover pure economic loss. So the harms covered by the PLD are death, personal injury, including psychological harm when it amounts to a recognized state of illness. It's property damage, including damage to data, destruction of data, but there are still restrictions when it comes to property and in particular data used in a business context. So it's only a very limited range of harms that are covered. And usually in the case of fraud, the harm is not covered. Having said that, the PLD could, of course, cover harms that are a little bit similar. For example, we are now seeing mass litigation, admittedly again in the US, where parents accuse social media providers not of offering products that are addictive, but of offering products that are not sufficiently safe and that allowed bad parties contact their children and kind of drive their children into suicide by way of a range of very malicious practices. And so that, in a way, is a related case. And there again, I believe that what we said earlier would hold true, that in principle, there would be routes to liability with a lot of hurdles to overcome. Thank you.
Probably a lot of.
If I may add one more point, and also looking at the follow-on question by the same questioner, I think the key distinction is one where between the AI system itself being somehow the source of the problem, or somebody using a digital tool to commit fraud. In that case, I think we are not in any way in the PLD. We are very much in the area of fraud, of criminal responsibility, and it would not be a matter that would be of concern under the PLD as it currently stands, nor should it be. They're two completely different things. So the misuse of a digital tool is quite different from a digital tool that's designed in a certain way or operates in a certain way that causes direct harm.
Yes, and has an inevitable effect because effectively it's got an inevitable defect. So Jan van Staldenun asks Pascal, you mentioned alternative or cumulative causal issues are a matter for member states law. To what extent can Article 13 of the PLD play a part?
Yeah, thank you very much for this very good question, because Article 13 deals with the reduction of liability. And indeed, if one looks at Article 13.1, it says, without prejudice to national law concerning rights of contribution or recourse, member states shall ensure that the liability of economic operator is not reduced or disallowed where the damage is caused by both defectiveness and by an act of omission. So in a way, one could at first sight think that Article 13 trumps any member state's law about ways of cumulative or excluding one another cause of liability. But you have the second paragraph that says that, economic operator may be, the liability of them may be reduced or disallowed where the damage is caused both by the defectiveness and by their fault. And so you have in the same article both aspects, in fact, because the proper aim was not to displace member states' law on that issue, right? So the question is always, if you have several causes, and you all know about the butterfly effect, how remote are the other causes, and if two are more or less on the same remoteness, then maybe both could be liable. And then the question is whether you have a joint and several liability system or whether one would displace the other. I would, of course, then consider that Article 13 plays a role here to say you cannot consider that if you have causes that are on the same remoteness, that one would displace the other, but you might have then joint and several liability, or at least some liability that should not be reduced. So I think what I've said is not displaced by Article 13, but it makes it even a bit more complex.
Yes, thanks for that. Let's come to Duncan Fairgreaves' question. Do you have views about whether it would be possible, excuse me, to bring legal proceedings against social media companies in the way you've suggested, or may it be argued that they're protected by an immunity of a statutory or contractual nature? And this is relevant in the US case law you referred to, due to the operation of Section 230 of the US Communications Decency Act. What about the European dimension, for example, safe harbor immunity? Who would like to deal with that? Maybe Pascal.
Maybe just first on the contractual issue, because one could imagine that there is an exclusion of liability for certain types of harm in the contractual relationship between the users and the social media and the platform. And there the question arises whether this exclusion of liability could be used to exclude liability on a tort basis. And you may know that in the ECTIL principles, there's nothing about exclusion of liability from contractual on tort. I've recently written on that. I consider that this could be applicable to some extent, but only when it goes not at the heart of the service provided. If you provide a service with some standards and then you exclude your liability for proving these standards, of course, you should not be immune for any liability. And we have also Article 6 DSA that plays a role in that respect. So certainly we are in a different situation from Section 230, but I'm happy for the others to complement.
Yeah, if I just have a couple of observations there, because we discussed this at length, in fact, when we prepared our supplement. And the crucial distinction is that we're not concerned with the actual information per se, because that is not included in the PLD, as we know, and it is also governed by the safe harbor under the DSA, for instance, or in the UK, the electronic commerce regulations, which are the old safe harbor rules. But what we are suggesting is that where you have an algorithm that either creates addiction by continuously flagging certain posts of a certain type, or reinforces psychological harm by continuously pushing information on a particular topic, for example, how to commit suicide, to use the most extreme example, then that is different from purely presenting information. Here, the algorithm has some kind of, if you like, editorial involvement in actually selecting and presenting information to the user, and that is different. To us, there is a qualitative difference between simply passively providing information, presenting information, or actively, through an algorithm, pre-selecting certain types of information and overemphasizing those. So there is probably a bit more of a different attitude in European law and indeed in UK law, compared to perhaps the Article 230 and freedom of speech interpretations that have been given in the US to date.
Yes, thank you. Thank you. Although it's a slightly fine distinction. And, I keep on thinking, how is this really going to work in practice if we have to tackle such fine distinctions? But let me just come to Diana Serini's question. Wasn't that the time to think about a form of compulsory insurance in consideration of the magnitude of possible damages? The topic was in 1985 critical and still is, but the idea to protect victims raises the point. What about compulsory insurance?
is the question compulsory insurance for the AI provider or for the victim? For the AI
I think it's
provider, of course.
compulsory insurance for the AI provider.
Yeah, and of course, here I can imagine that an insurance would be welcome, of course, but that does not solve the problem of liability, of course, because the insurance will only come into play once the provider will be held liable. And as I tried to show, that might be, I mean, you have to go on a lot of hurdles before you get to that end. So it's a matter, of course, of development to see whether that makes sense. But I'm not totally sure. But yeah.
And
No, I
also,
think
there is experience, of course, of such insurance schemes. I believe it's New Zealand, which has operated a statutory insurance scheme for product liability instances. And my understanding is that that scheme hasn't been terribly effective in providing sufficient compensation for victims. It's all been done on a fairly sort of standard tariff basis, which doesn't necessarily allow full recognition of the actual loss suffered. Furthermore, if you have an insurance scheme, the obvious question is who funds the insurance scheme? Where does it all come from? And these things have always been in the background. They were, in fact, mooted in some of the earlier commission documents on the digital law area before, in fact, 2019 and sort of the early papers 2016, 2017. But there was always a reluctance to go down that route because of the complexities of such a scheme.
yes, actually causes displacement activity. If you have compulsory insurance and tariffs, people try and make claims that are not within the tariff, and that creates even more difficulty than if there had been no scheme in the first place. I just want to ask Marinella Bashira's question, which is primarily for Pascal, but it can be for everybody. Do you think the PLD could come into play in the case of open access sources of software, or in case of communities of users where contractual relationships between providers and ultimate users might be regarded as gratuitous?
So first of all, gratuity cannot be a defense for liability. So that's the first point. But the more difficult issue is, of course, the causal link. Well, defectiveness, of course, that will always be difficult, as we have seen, but also the causal link between what one party has done in this community and the other, and to consider that the whole community is liable in a sort of a common fault. I wanted to say seems very difficult to me. That's why I frankly have difficulties to see how an open access source of software could be triggering a liability for any person who has acted, unless, of course, one can demonstrate that what has been done by one party, maybe also, with a clear element that creates the particular element, and that you can find a causation between what has been done and the outputs. But that means almost it's no more a community. It's one single party who finally edits something specifically. So I have difficulties, I have to say here, to see an issue.
Well, thank you. Now, Christiana.
Yes, maybe just to add that there was a history. I mean, now Article 2, Para 2 says this directive does not apply to free and open source software that is developed or supplied outside the course of a commercial activity. That clarification was added rather late in the legislative process, because the initial view of the European Commission was that when you say placing on the market, for example, that already implies a commercial context. So the Commission took the view initially that it goes without saying that those offerings outside a commercial context would not be covered. But later then, upon pressure from the open source community, that explicit carve-out was created. It is, however, always disputed, right? Already this morning I had this debates with journalists on the Artificial Intelligence Act, whether the partial, very small carve-out for open source is justified or not, because On the one hand, you want to have a privilege for open source. On the other hand, open source products can create as many risks, or at least as many risks as others. So this is always a kind of tightrope exercise, but by and large, this is what the European legislator has done here.
Thank you. Does anybody have any comment on the question of Dr. Abdinessa? How can the difficulty of proving criminal intent be mitigated when errors cause harm in the digital environment?
I think that's probably for another day.
It's a question beyond. It's a question beyond product liability, I believe, and I think it's a very important question. Then, how do we apply traditional law that has been designed with human actors in mind when we have AI agents? I think this is a very big question that is being raised here. There are academic views as to how these questions can be overcome. I myself have drafted a set of principles, for example, how to deal with such questions in a contractual context. So when contract law uses terms such as intent or also other terms actually like awareness, knowledge, or standard of care or something, how do we translate that into an environment where AI agents are the actors? But I think this is a bigger question that goes far beyond product liability and probably cannot be answered here.
Can I, we're coming to the end, and I want to ask each of you to give 2 minutes thought to the question of the future, to how this is going to work out as time progresses. Obviously, we'll see what the Court of Justice comes up with. We'll see how cases are decided between information and software, between services and products. But I wondered whether you could give some thought to how these perhaps fine distinctions that have been encapsulated in the legislation will actually present themselves and give rise to consequences in real life. Now, Pascal has dealt with the practical consequences of causation and burden of proof and the ways of proving your claims and the presumptions in the legislation. But I'm just interested to see how in Europe this might play out, as against in America, where we see many claims being brought in America in this space, some of them succeeding, some of them being met with defenses under the First Amendment, some of them failing, with no consistency across the piece. In different states, different outcomes. Eventually, I assume the US Supreme Court will have to decide, but even then, there's so complex that it may not be just one decision. How do each of you see this legislation operating in practice? Will it be successful? And will it take a long time to work out the answers? I don't know who wishes to go first, since I've only just posed the question.
I'll stick my neck out first, and then Christian and Pascal can rescue me, which undoubtedly will be necessary. But basically, obviously, there will be a time delay before we get a clearer sense of how the new legislation will operate. It isn't actually yet enforced in the member states, if I'm correct. I think that's from December. So we don't actually know anything, and won't know anything for at least several years, I would imagine. But and I think we all are expecting these cases to reach courts in the European jurisdictions sooner or later, and I would imagine sooner, because this is such an important issue. If you look at some of the litigants who've gone across to the US to litigate there, it is because there wasn't yet a basis for doing so in Europe. That basis will now soon be there, and I would imagine these cases will come to court. Yes, you're absolutely right. There are some very fine distinctions, or some very, potential grey areas that surround the distinction we've drawn. But in many ways, and as lawyers, I think we can all accept this, in many ways, there will have to be room for argument to deal with quite a varied and complex digital landscape. If it was easy to say there will be liability in all these circumstances, then I think we would run into the difficulty that Pascal highlighted, which is that we would undermine innovation in favor of clear, bright line consumer protection. So some of these fine distinctions that you are concerned about are possibly necessary to find a right balance between all these different competing and sometimes conflicting interests. I would expect some cases to come through, although I'm not sure how quickly that will be. I'm thinking back to the experience of the UK's Consumer Rights Act, which was, of course, ahead of the EU in putting in contractual liability for digital content back in 2015. And to the best of my knowledge, there hasn't been any litigation that reached the higher courts on any of the aspects of that element of the CRA. Now, either that tells me that these things are not going to court, they're being dealt with elsewhere, or that it hasn't yet been a sufficiently large amount of money at stake. This might now change because the number of victims that might be identified as a result of some of these instances we've described is going to be much larger and will probably make it something that could go to court sooner rather than later. That's my view.
Thank you so much, Christian. Christiana.
Yeah, I would agree with what Christian has said, and maybe just to add that we have to bear in mind the Product Liability Directive is not entirely new. It builds on the concept of the 1985 directive. So we have 4 decades of case law, both in the member states and by the Court of Justice, which is, of course, the decisive thing. So at the end of the day, there are not so many entirely new elements. What is new is the explicit mentioning of digital manufacturing files and software. So this we dealt with at length during this webinar. What is new is also that updates are brought into the equation, updates as well as related cloud services and the like. And then we have those new provisions on disclosure of evidence and burden of proof, with which Pascal dealt with extensively. So there are a few more minor novelties which I now didn't mention. But by and large, this is very much what we know already from the 1985 directive. And even the novelties I have, the innovation I have now mentioned, there is a dispute whether they were already in the 1985 directive, because the Court of Justice never explicitly said the 1985 directive doesn't cover software. It simply didn't say so. So at the end of the day, I think we have a pretty solid baseline of case law on which to build. And I'm pretty convinced that the remaining open question will come to the European Court of Justice very soon, because I know of several big collective actions that are being prepared against social media providers and others. And I would be surprised if the courts waited until the last instance. I think the first instance will already send the file to the Court of Justice to create certainty rather soon. So at the end of the day, I think the product liability is a good legal instrument. It provides a sound basis. There are certain uncertainties, but I'm quite confident that the courts will create certainty over the next few years.
And as usual, ELI leads the way in explaining the difficulties and helping people understand them. Pascal, just 1 minute, please.
Well, yeah, of course. I will be very short because there's not much to be added to what has been said. Apart, maybe from one aspect, I'm not sure we will be able to create certainty because this is not of our world, but we will at least add a bit more certainty than what exists. But maybe just 2.1, there will be a competition of fora, I think, between the US and Europe, also linked to the full disclosure proceedings in one area, but then the problem of First Amendment on the other side. And here, a more limited aspect. So depending what you need for your case, you might be better off on one side or the other side of the Atlantic. And the second aspect that will be central as well is really agentic AI. And to what extent, when you get with agentic AI on the top of the functioning of these social media, the landscape is changing a little bit, and how difficult it becomes to say what is the cause, where it comes from, and so on. So I think that we will still have to discuss it more in depth when we will have the first cases coming, because that will be really fascinating.
Thank you very much indeed. Thanks to all our speakers. I think they've done a magnificent job in explaining what is an extremely interesting and obviously very important subject, both in Europe and further afield. So I will now close the seminar by thanking them, and I very much hope that everybody who's joined the seminar has taken something useful away from it, and that ELI's work in this area, which has been so important, will continue. Thank you all very, very much indeed.
Thank you. Bye-bye.